Hello, everyone. How are you doing? Welcome to Uncivil Law. Hope you're doing a good day. And yeah, welcome to the channel. Welcome, everyone. As always, I hope you're having a wonderful day. And we are here to discuss one of my favorite topics, to talk about PACER. We're here to talk about access to justice. We're here to talk about access to courts, access to cases, access to decisions, and we are going to cover that. And I want to thank a person in the channel, Burner, for hello, Backleaf. Yes, hello. How are you all doing? I want to thank Burner for his bringing it to my attention in the Discord, because it's an issue that I have some issues with, because I like to get access to cases from PACER, and I have to spend money, and I would like to spend less money. I think that, it should be available to all. So let's talk a little bit about where we are and why we are where we are. We started this action in the Court of Federal Claims, which is a court that deals with claims against the government for money. So if you're looking for money from the government, then you're probably and almost certainly in the Court of Federal Claims. Obviously, if you're seeking other kind of relief, injunctive relief or declaratory relief, or trying to strike a statute down, stuff like that, you normally go to your normal district court, normal court of appeals, all that good stuff. But if you're seeking money, you are in the Court of Federal Claims, which is the court that deals with this. That's the district court. It's called the Court of Federal Claims. It's the district court. It's a trial court, and it has a special name for it because they deal with all federal claims, so it doesn't have a geography. And cases that are appealed from the Court of Federal Claims goes to my Court of Appeals, the Court of Appeals for the Federal Circuit. Yes, the Court of Appeals for the Federal Circuit. They not only do all the patent cases, they also do all the claims for the federal government for claims of money. So that is where we are, the Court of Federal Claims. And the issue here is access to PACER. And I want to read you the statute, I want to read you the law. It's not in the U.S. Code, because not every federal law is in the U.S. Code, right? There's federal laws that are not in the U.S. Code, so I'll read it to you. This was made law by Public Law 104-317 and amended by Public Law 1103854 if you want to, or Public Law 107-347 if you want to look it up. So those are the relevant things, and here is what the law says as it relates to this. Court fees for electronic access to information. Subsection A. The Judicial Conference, which, as the name implies, is run by the Chief Justice and is the group that does a lot of things about relating to courts in terms of administration of courts. The Judicial Conference may, only to the extent necessary, prescribe reasonable fees pursuant to various laws for collection by the courts under those sections for access to information available through automatic data processing equipment, like the internet, for example. These fees may distinguish between classes of persons. The idea here is like pro se litigants, different kind of litigants, academic researchers, scholars, general public. They get different fees access. These fees may distinguish between classes and shall provide for exempting persons or classes of persons from fees in order to avoid unreasonable burdens and to promote public access to such information. The Director of the Administrative Office of the U.S. Courts, under the direction of the Judicial Conference of the United States, shall prescribe a schedule of reasonable fees for electronic access to information, which the Director is required to maintain and make available to the public. Subsection B. So the key word from subsection A was only to the extent necessary. So it's only supposed to be what is necessary for the cost of the program and nothing more. That was the key words from section A. Let's look at section B. The Judicial Conference and the Director shall transmit each schedule of fees prescribed under paragraph A to the Congress at least 30 days before the schedule becomes effective. All fees hereinafter collected by the judiciary under the paragraph A as charged for services rendered shall be deposited as offsetting collections to the Judicial Automation Fund pursuant to law to reimburse expenses, and here are the key words, incurred in providing these services. So the way I read this law is that you're only allowed to charge as much money as you need to get the service up and running and, functional, and you can only charge fees for that to the extent necessary and nothing more. Well, the judiciary didn't see it that way. The judiciary did not see it that way. Because the fees used to be 0.7 cents per page, and then they increased to 0.10 cents per page, or 10 cents per page. So no, let me rephrase that. It was 7 cents per page, and then they increased it to 10 cents per page, even though electronic information got cheaper. So the administrative office didn't point to any growing costs in providing access to records through PACER, which would be hard because things got cheaper. Instead, the administrative office relied on the fact that Judicial Information Technology Fund, the account in which PACER fees and other funds, including appropriations, are deposited, could be used to pay for the cost of technology-related expenses like the ECF, which deals with electronic filing. And they stated no authority for the increase, so they're using it for other stuff. Now, the ECF probably wouldn't be so bad. You could argue that's tied into PACER and electronic access. It's for electronic filing instead of electronic receipt of stuff, but you could fold it into that language, I think. Less justifiable, however, they had an excess of $32 million of fees from PACER in this fund, which was used to fund things like courtroom technology for installation of TVs, replacement of equipment, and infrastructure maintenance. So it was used for things other than the electronic filing and electronic receipt, including all new technological choice. So, long story short, the government embezzled its own money. Yeah, so that's what's going on. So, this is one such case. The most notable case in this, Natural Veterans Legal Services Program, and also Alliance for Justice versus the United States. So they're saying, hey, police spend money on PACER for PACER, not for the least of reasons that PACER itself could use some love. It's set back a couple of years in terms of search engine interfaces. It's workable, but it could use some love. And, you should use money for that and probably reduce fees. All that good stuff. So that is the argument. So we're going to listen to the oral argument for the that they did today in the Court of Appeals for the Federal Circuit. And on screen, because we don't have video, we only have audio. This is a picture of the Court of Appeals for the Federal Circuit. I have been in that building before. It's a very nice building. It also sits catty corner to the White House. Were it not blatantly illegal, you could throw a rock from there and hit the White House, pretty much. It's right next to Lafayette Park. So it's right next to it's basically right next. It's right next to the Treasury building, which is right across the street from the White House. So it's really, really close to the White House is basically my point. And yeah, that is what it looks like. It's a courthouse. It has courtrooms. It's a little bit old in sort of the way it's structured, but kind of fits with the theme, right? It's a perfectly fine building. I've looked out those windows before into the street. So that is what we will get to watch, and now we'll just have oral react. So let us do with that. Yeah, I also do not recommend throwing rocks at the White House. It was just an example. Rock throwing distance. Yeah, so I don't do it. It is a pretty building, and there's like the Dolly Madison house is attached to it and stuff like that. So it's really cool. And it's a cool building. It's kind of small, all things considered, but it's very functional, and I've had cocktails in that building, so we're familiar with it. So let us get started with the oral argument for this, and we'll just watch this and respond and see how it goes, I guess. I know. I would not recommend bringing a firearm into the courthouse. No, that's not a good idea. The U.S. Marshals who guard the building may have questions. So I wouldn't. Also, it's illegal. It's a violation of 18 USC. Is it 930? Yeah, 18 USC 930. You can't bring firearms into a courthouse. So don't do that. All right, let's listen to this oral argument. Hello, Dominican Republic.
Good morning again. Our last case this morning is National Veterans Legal Services, National Consumer Law Center, Alliance for Justice versus the United States, 2019, 1081 and 83. Mr. Gupta.
Good morning, and may it please the Court. Deepak Gupta for the plaintiffs. This interlocutory appeal properly presents just two legal questions, one jurisdictional and one on the merits. And although the government tries to bring in new arguments under the rubric of jurisdiction, I think the only question that properly goes to subject matter jurisdiction is this. When a plaintiff who has paid a user fee to the government challenges that fee as an illegal exaction in contravention of a federal statute, is that a claim for which the Tucker Act provides jurisdiction? And the overwhelming answer offered by the Supreme Court's and this Court's precedent, stretching back over a century, is yes. It is Hornbook law that, as this Court put it in Arrow.
Pause. The Tucker Act is an act that allows you to get monetary damages for breaches of contract and things like that. So that's what counts as. Yeah. Yes. Section A says that. Matthew, did you get down to Section B? Did you get down to Section B? So 930A says that. Did you get down to Section B? Let's carry on.
Yes. That the Tucker Act provides jurisdiction to recover an illegal exaction when the exaction is based on an asserted statutory power. In fact, we don't know of any case, I don't think the government has identified one, in which this Court has held that it lacks jurisdiction to determine whether a government-imposed fee is unlawful and should be returned to those who paid it. Now, in this appeal, the government attempts to manufacture doubt on this score only by plucking some dicta, we think, out of context from this Court's decision in Norman.
You don't have a lot of time. Do you mind if I just turn you to the merits?
Sure.
And I want to ask you this hypothetical. I mean, the statutory language, because it's got a lot of stuff interspersed between the operative language, is a little hard to parse for me. But as far as I can tell, it authorized the judicial conference to prescribe fees for the public accessing information that's available through automatic data processing.
Right. There's no dispute on that score, Your Honor, but I think...
So here's the question I have, though. If at the time and I know that a lot's going on back and forth since this was first enacted, there was amendments the government's doing, or the judicial conference. Sorry, I'm going to say the government, unfortunately, instead of the judicial conference, just because I'm used to saying that, and I understand there's a difference here. The judicial conference has gone through many iterations of this electronic CMECF and all that kind of stuff.
Right.
But suppose hypothetically, at the time this was enacted, the judiciary was being really, really slow about providing electronic access. And even though all the judges and the clerk's offices and stuff were writing stuff on word processing equipment and everybody knew it was there, they refused to provide any electronic access. So Congress, in an attempt to prod them, said, look, we know you have this stuff available electronically. We're going to let you have fees to recover the cost of providing it. Do you think those fees would include more than just the marginal cost of providing the information? Would they include, if the courts had never done it before, the infrastructure to do that?
Yeah.
The servers and all the like, the interfaces on the internet and whatever else was necessary.
Right. I think that would be there would be a stronger case, certainly in that scenario. And it's a little hard to know because I don't know exactly what your hypothetical statute looks like, and I think that matters.
Well, it looks like this one. That's the point.
The same statute, but I mean, in the very beginning, when someone had the ability to communicate with the court and say, please send me an electronic copy of the brief and so.
Right.
And that whoever took the information, the court said, well, we don't have electronic, we got it in paper, we have to digitize it.
Right.
So we have to go to the expense of converting paper into digital information, and then we can send it back to you.
Right.
So in the very beginning, would it have been reasonable for the judicial conference to have said, we're going to recoup that creation cost?
It certainly would have been more reasonable than it would be after the amended statute where the Congress said, we see that you're charging more than the marginal cost of disseminating this information and essentially cut it out. Please charge only what's necessary. But I think
isn't it true that in the very beginning, very few courts had digitized information? It started in Northern District of Ohio. So it's very interesting because the PACER user who's coming in electronically and dial-up to the court saying, please send me this digital information. The court said, we don't have digital information. We'll create some for you.
Right.
So the burden in the beginning was on the government to make the cost to build up an electronic database that they could easily and cheaply transmit backwards. Once ECF comes along, the burden goes on to the private practitioners and whatnot to create the electronic information that they ship to the courts, that the courts save and then ship back.
Right. So I think it's important when you're trying to interpret the statute to remember that the Supreme Court has provided a jurisprudence for how to do statutory interpretation where you have a user fee statute. And what the Supreme Court has said there is that the charge, unless Congress specifically directs otherwise, and there's a clear statement requirement, the charge is for a specific service to a specific individual for a specific cost.
Sure, I get that.
But this is a fee tax issue, right?
But that's the problem is, to me, none of that solves the problem, which is what was Congress talking about when they said you can prescribe fees for access to information? Right. Did it just mean the fees involved in sending the information back to you, or did it mean the fees, as at least Judge Hubel found in part, for building out the underlying infrastructure that made that possible?
Well, remember that the class period here starts in 2010, and the statute that we're dealing with, the amended statute, was in 2002. By the time you get to 2010, the infrastructure is already created. And
Matthew, this is an appeal. So this is an appeal hearing, I guess you'd say. We're on appeal. Yeah, so can you use money from the fund to pay for the building out of the infrastructure? Yeah, I think so. That's fine, but as he's pointing out just now, the class is only from 2010. The infrastructure had been built. So, that's fine. They're going off the rails and don't exactly follow protocol. Well, it's what do you want? It is what it is.
And what
the
Senate report
has been created, but it needs to be maintained and updated.
Right.
And we constantly are shutting down our EMCCF program here in the court to make adjustments, and that costs money to do that.
So I want to answer the question. Let me just first say there are categories of expenses here that are neither CMECF or PACER, right? The funds are being used for, notices to crime victims, flat screens for jurors.
The four categories that were identified.
Right, and those.
Sir, I'm not asking. Let me make it clear.
Right.
Maybe my hypotheticals. You're afraid that I'm trying to trap you. I am not. I am trying to draw the line between your argument, which is all the way just the marginal cost of providing access, and Judge Hubel's middle position. Right. I understand the government's going to go further and go the other way. Right. They can argue that when they get up. Right. But it is not a model of clarity in terms of statutory writing. We see this all the time, obviously. But why is Judge Hubel wrong that the underlying, and maybe you disagree with this characterization, but what I read her opinion as saying is the the underlying infrastructure costs that are attributable to providing access are also recoverable, not just, as you said, marginal costs.
What's wrong with that argument is that's all bureaucracies are going to want to do that with user fees. And what the Supreme Court's and the lower court's user fees jurisprudence is designed to do is to hold the line and say, look, you can charge for, as the Supreme Court put it in New England Power, and a reasonable charge is is made to an identifiable recipient for a measurable unit of government service. And I think that's the marginal cost.
That doesn't answer whether it's not just the marginal cost, though. I mean, it doesn't answer the question of whether the portion of the underlying infrastructure that supports public access versus what we do internally as a judiciary is also properly chargeable.
Well, one good analogy, I think, is the Freedom of Information Act. Every agency charges people fees for getting records under the Freedom of Information Act. What they can charge is the marginal cost of disseminating that information, copying it, searching for it, making it available. What they cannot do is attribute the cost of collecting that information or maintaining a records room and then putting that on the users. I think a similar line can be drawn here, but I also think...
It's a good analogy, but unless I see the statutory language and see what it's actually saying you can and can't collect as FOIA fees, it doesn't answer the question.
And I understand the frustration here because Congress said, to the extent necessary to reimburse the cost, and then you have to wonder what is the cost. And I think...
Well, that's why I asked you the initial hypothetical, which is if there was none of this infrastructure in place, and Congress said, look, judiciary, go out and do this, and you can get fees to compensate for this because we don't want to give you a general appropriation, then wouldn't it seem natural to read this as allowing for fees to cover both the marginal cost and the infrastructure?
In that circumstance, they would have a better argument.
Personally, I think the answer is yes. I mean, the way I read the relevant statute and the way that I read the relevant phrasing, right? So Section A talks about necessary and Section B talks about for the dissemination of the cost. The exact language is to reimburse expenses incurred in providing these services. And then Section A talks about only to the extent necessary. So I'm not 100% sure why he's fighting this or what his concern is. Can the government use the money to build out the service? Yes. Can they use the money to improve the service? I wish they would, and yes. Can they use the money for the cost in sending out records? Yes. I don't really personally have a problem with that based on the language. I mean, those seem like expenses incurred in providing the services. Could they pay someone to write them a better search engine? Yes, and I wish they would. Could they hire Google to help? God, please do that anytime, and yes, I think that's fine. Those would all be reasonable expenses in doing the service. So I'm not sure why he's taking the position that he is, because to me, the answer is, yeah, no problem as it comes to PACER. All this is fine. All this is fine. You can pay for the costs in providing the services, including the building of it, including the maintenance of it, including the electricity, presumably, for it. You can charge for all those things. That's fine. Can you do it for ECF? Well, it talks about in Section A, reasonable fees for electronic access to information, which the director is required to maintain and make available to the public. ECF doesn't quite fit into that language, but if you want to stretch the language to go to ECF, I'm not going to give you a super hard time. It does help the public in terms of filing. It helps the public in filing records. So, if you want to call it as access to information, ECF, then, okay. And besides, it's helped get the records into the system so that they can then put them out in PACER. So, one of the things that makes it available to the public is that it's filed. And so, you can make a connection there. Whether or not you buy that connection or not, I think is a reasonable point of debate. If you want to say ECF is not covered in this language or not reasonable, I think that's a very reasonable position. And I'm just giving you some ideas of how you could bend this language to cover ECF. You say, yeah, we have to have fees for electronic access to information made available to the public. Well, the only way we can have that information to provide is if it's filed in the first place, and this ECF makes it easier to file. So, okay, well, But can you use it to buy TVs in the courtroom? No. That is a bridge too far. So I'm not 100% sure why he's taking the position he is and equivocating the way he is, Because to me, it's like, it's not that big a deal, but, you know, they didn't hire me as the lawyer, so what do I know?
But when you get to 2002, and Congress amends the statute to say, you know, this is all up and running, right? We see that you are charging more than the marginal cost of disseminating this information. We want you to move to a fee structure that makes this information freely available to users to the extent possible. And then,
but they didn't say, you can only get your marginal cost. They said to the extent necessary.
Well, the marginal cost language is in the Senate report, not in the text of the statute. But I think it informs what...
Why does that govern?
Well, I think for those who use legislative history to inform their understanding of what the text means, when Congress said you can charge only to the extent necessary, I think that is an indication of what Congress meant. And it is consistent.
Sure, but, I mean, look, the legislative history here is helpful to you in some places and is helpful for the government in other places, because the House report early on says that one of the things that will be helpful to enhance access to the public is, this is from the 1996 House report, is enhancements for enhanced use of the internet in electronic bankruptcy filings and things like that. When I read enhanced use of the internet, it sounds to me like enhanced capabilities to have better portals and things like that, which again, it sounds like infrastructure rather than just here is a way to get these documents.
Well, it's true that Congress is encouraging, the whole point of the E-Government Act was to encourage the courts to be more transparent in various ways. But I think the Senate report is the only time you're actually seeing language that's pegged to what does only to the extent necessary mean. Let me also suggest, if you're looking for something like a middle ground position between Judge Havel's view and our view, one way to handle this is you have an interlocutory appeal here. You're being asked to interpret the statute. And I think what you can do is interpret the statute, but then leave it on remand for the government to be able to argue that within this CMACF bucket, we don't really know, there's been no discovery, we don't know all of what falls under that bucket. The government could argue we need some of this is absolutely necessary to disseminate these records to users. We don't think that's the case. But
we don't have the nitty-gritty in the numbers in our hands. So, I mean, when they talk about, the cost of maintaining the CMECF, I don't know what that means. If it means simply expenditures that the court can identify that unless we make these expenditures, this service will be impaired, or the service will not be as good as the customers want it.
Right.
So enhancement, somebody comes along and says, I can figure out a way to make PACER requesters who ask for information can get it demonstrably faster.
Right.
Then that's something that the user wants. And if it costs something to do that, it would seem to be reasonable to allow the fee to embrace that cost.
Yeah, and I mean, I understand all you have here.
If the cost is for decorating the office of my ECF officer in the court, I'm not so sure that qualifies.
Right, and we know that...
We don't know from the record that Judge Havel's going to get to do that, right?
Right. I think that's the best course, is to send the case back down, and on remand, let's see
with a clear explication as to what we're talking about in terms of costs beyond what you call marginal costs, and what the government may try to tell us on its side what it thinks that bundle looks like.
Yes, Your Honor, because all we have here right now is just a spreadsheet, and so I don't see how you have the tools available to you to really discern what's behind that. But we do know that CM and ECF are sort of two different things that have been merged. CM...
You can't have PACER without it, right?
Well, you could. I mean...
Well, what's a PACER user want?
A PACER user wants to download PDF documents of court records. Right.
Which have been filed through electronic means.
Which have been filed through electronic means in the same way that, if any agency runs a records room, there's some process for gathering those records.
Everybody now creates a digital record and sends it to us, and we store it.
Correct.
And then we massage it for judges getting access to it internally or outside people getting access to it.
Correct. And all of that benefits, there are lots of components of CMECF that benefit the courts internally. There are case management systems just for the courts. And there's also features that are for the convenience of litigants.
And all that was known to Congress at the time Congress learned that CMECF was going to be used and PACER would have access to it.
Correct.
Correct. So the Congress clearly knows that there are beneficiaries to this structure.
Yes.
For which a fee is charged other than the users.
That's right. And Congress didn't say, you may charge this fee to the users and use it for things that benefit other people.
Counsel, you've just about used your rebuttal time.
Sure.
Let's hear from the government.
Okay.
And we'll give you back 3 minutes.
Thank you.
Well, I don't really know. I do think there is a problem of mission creep on this issue, right? It's a big pool of money, and so it's like, well, how can we stretch the pool of money to cover other things other than PACER? So one of the things they're talking about is the ECF, which is the filing tool. Then they talked about CM, which is case management, right? Which is primarily a tool for the courts to use it, which really doesn't probably flow from this. And then there's all the TVs and stuff, which definitely doesn't flow from this. So, and I think, I'm not quite so sure why he was being so hesitant about can they use the money to improve the infrastructure or create the infrastructure for PACER. I think the answer there is clearly yes. I mean, that's part of what the money is for, right? It's to have the system, and the system needs improving. And then you need to spend money, sure. If you need to hire someone to develop a better search tool for you, sure. If you need better storage mechanisms or more internet bandwidth or something, then sure. So to me, I think the answer is, yeah, you can use it to build and maintain and improve the system. You can use it for the marginal cost of sending out data. The question on ECF is questionable at best, because I think it's a tough read on the statute. I think you can get there. I don't think it's completely absurd to get there. It's not probably what Congress had in mind, and I think you're kind of reading more into the words than are really there. But I think you can get to ECF, and then to TVs and stuff. No, I don't think so. So I'm not quite sure why he was being as cagey as he was, because I don't think that that's going to be a winnable position. I think the winnable position is much more, yes, they can use the money to fund PACER, which means the creation, maintenance, improvement thereof, and the marginal costs in supplying the data. That seems completely right. And if he wants to limit it to PACER only, then that's the right answer. And then when they ask him about ECF, he gives the answer, well, the statute says, providing information to the public, and CM isn't about that, because CM is about filing, not the information to the public. So you can't use the money for CM or for ECF. He could give that answer. So this is not the position I would take if I were arguing this, as was one of the main reasons that, if you're the client out there watching this video, hire me. I've got better arguments. So let's see, because I don't think the court is going to buy it. And as always, one of the problems of a lawyer is when you go too far, it has a nasty tendency of kind of ruining your credibility, or like you're asking for too much, and it kind of hurts you on the things you had an easier time on. So like if you have a slam dunk issue and you start talking about things that are way off, then it has a tendency of like causing doubt to be read onto the slam dunk stuff where there shouldn't have been doubt. Whereas if you just hit your strongest argument, you're better. This is also like why on appeal, lawyers struggle with how many issues to bring into appeal. Like if you have 10 issues you could bring into the appeal from the lower court, if you don't bring it in, you lose it. So there's that. But if you bring in weak sauce, the weak sauce tends to kill your good stuff. So you were faced with this wonderful tactical consideration. What do you bring and what don't you bring, as a lawyer, and, all good stuff. So let's just keep listening on and see what's next, I suppose.
Ms. Klein.
May it please the court. I know the merits are interesting, but I'd like to start with jurisdiction, because we don't think Congress authorized this court or Judge Uncivil to be engaging the merits in this way. And I can be brief, but it's extremely important to understand the three central features of this statutory scheme that show that Congress did not impliedly create a damages action for an individual PACER user. First, whose decisions are at issue here, They're the decisions of part of the judiciary, the judicial conference chaired by the Chief Justice. And Congress exempted the judicial conference, judiciary at large, from review under the APA.
But not from the Tucker Act or the Little Tucker Act.
We're now talking about, that's correct, but we're talking about whether to infer a damages remedy that is not express. And to get so, like as with any statutory interpretation question, you look at all of the relevant indicia.
Let me ask you a hypothetical. If instead of giving complete discretion to the judiciary to set the fees, Congress had said, we want all this to happen, you charge 10 cents per page or whatever the actual cost to you, whichever is lower. Is that a statutory charge that would lead to an illegal exaction if the court implemented it improperly?
Generally speaking, no. I mean, saying like when Congress says to the judicial, because generally speaking, these fee structures they're administrative billing mechanisms, but Congress hasn't set up a damages remedy. So, for example,
wait. You're saying that if Congress enacts a statute setting a fee, a specific fee, and says, government, you can collect X amount, and just put aside, if you have any separation of powers concerns, just assume we're talking about an executive branch agency. I don't see any difference between the two for this kind of claim myself, but if it makes it easier for you to answer it, assume it's an executive branch agency. And that executive branch agency goes out and collects double what that statute is. Do you think Congress has to actually say in that statute that if the agency collects more, you can sue under the Tucker Act?
Well, we do think it would be different for an executive branch agency, that the normal avenue would be to challenge the agency's action under the APA and get the money back from the agency's budget, not an implied damages remedy against the United States.
But that's a typical illegal exaction claim.
Well, let me identify the three differences here from what we'll call the typical illegal exaction claim. First is we're talking about a decision maker that is...
I think we're more interested in merits, and I don't want to run too much of this, but what you seem to be arguing is something that the government has continuously argued in all of these Tucker Act and Little Tucker Act cases is that even if the case involves money at some level, you have to read a further intent into the statute or the contract or whatever is the money mandating supporting piece of jurisdiction to allow the Court of Federal Claims or the district courts under Little Tucker Act to exercise jurisdiction. And haven't we routinely disagree with the government on every single one of those cases if it is a case where the underlying instrument, whether it's a contract...
I like her first point. I think it's a good point. I really wish, the same as the guy, I wish they'd let her talk. I wish they'd let the guy talk. They kept interrupting him. When she says, okay, you don't have jurisdiction, and you don't have jurisdiction because the judiciary did this, so you can't get under the APA because the APA only deals with the executive branch, so you can't get it under the APA. That seems reasonable. And there's an exemption for the judicial conference, which all this permeates from. It's like, okay, that's a pretty good argument. I don't know if it's a winner yet, but you've got my interest. You've got my interest in the argument, and I really wish you'd let her talk so I could hear her argument and decide whether I agree with it or not. I was like, well, that seems like it could be a good argument. I'd really like to hear more to decide whether or not she's right, because, okay, you have my interest. You might be right. Could you tell me a little bit more? No, apparently not, because we have to have the judges talking. This is the Federal Circuit loves to hear themselves talk hour. It's a little frustrating because I'm like, oh, yeah, it's actually, that seems like a plausible argument, counselor for the United States. That seems plausible. Tell me a little bit more. And you had two other points which we haven't heard yet. Yeesh.
Where a statute involves money. Sure, there are outlier cases like Norman where it's about land as opposed to an actual statute for money. And I can think of some other Tucker Act cases involving contracts that weren't actually about money. But when it's about money, isn't the implied remedy for wrongfully paid over money either a breach of contract claim or an implied or an illegal exaction claim?
Well, for Cyprus Amex, which was about money, taxes illegally collected, the court correctly set out the inquiry, which is you have to look at the substantive law to determine whether it was intended to provide monetary compensation. That was this court unanimously in Cyprus Amex. But here, even if you use the narrower jurisprudence of legal exaction, the claimant has to be able to plead and then show that the particular amount sought, the particular amount was illegally exacted. And because of the way this statute is written, which is in aggregate terms that do not, like the old shipping cases, allow the determination of what a correct fee would be, it is impossible for any PACER user to make that showing. And remember, this is a class action. It's just a collection of individual claims. And as defined by plaintiff, each download for which a charge was paid.
That sounds like a damages question to me.
It's not.
We know that there's a class of people that have paid, at least under their theory, if we agree with them on the merits, there are a class of people that have paid more money that they should. How much they should get back depends upon the court determining how much is in excess and then coming up with some kind of formula, doesn't it?
No, Your Honor. So let's just imagine an individual PACER user says, in July 12th, 2014, I paid $1 to download a document. Even if you imagine certain expenditures were not made under the statute, okay, whether they're Judge Uvell's categories, whatever categories they are. If you look at actually the substantive statutes that govern the judicial conference's fees and expenditures, first you see under 28 U.S.C. 612, you can carry forward surpluses, which they do routinely, $40 million a year. This is because IT projects are not conducted within a fiscal year. So even if you imagined, okay, we're just going to not spend that money, whether it's on, web-based juror services, whatever, they could carry it forward. Second,
what's that got to do with whether or not a portion of the fee was illegal?
Because they could say
the fact that they can carry it forward and use it for something else.
They wouldn't change the fees. So they're saying like, look, okay, we're not expending.
The only time they're going to change the fee is if the court tells them that a portion of the fee is illegal.
This is now, it's getting circular, but
Judge Uvell won't have any trouble at all at the end of the day giving a precise number to say what portion of the fee was illegal.
No, actually she will. I mean, what the
there's a slight weakness point in her argument there. Like her argument is it would have been the same, right? So her argument so far is, well, among other arguments, but her argument is at least in part that, okay, you get charged $1 to download a document. What they are spending that dollar for on the other end is irrelevant to you in terms of paying the dollar. You would have had to pay the dollar either way because they would have been able to carry it over for IT projects and whatever. So even if they're illegally spending it, it's not being illegally collected from you because you would have had to pay the same amount in any event, which means that you don't have standing and vicariously, and therefore no one has standing, which is actually a pretty good argument. The problem is, like, the way the statute reads, it talks about you can only collect the amount necessary for the distribution of information electronically. We discussed the language, right? So, to the extent that they were expending money on TVs and other things that were not appropriate, then there's nothing like to cancel. There's nothing else to like spend money on, right? They should have spent money only on this. They spent money on this other thing. That's part of the reason they need more fees in the first place, because they would need to spend more money than they were allowed to spend. So the fact that they bought TVs actually does harm me, because part of the fee I paid, part of my dollar was to fund a TV, so it wasn't properly collected, and therefore it does harm me personally. I should only pay 99 cents instead of $1. And so I think that's a weakness in her argument. Now, she's right about the carryover thing, but like even then you'd have to like justify like the amount of carryover. It's like, yeah, IT projects need money over time and you need to carry over some money. Okay, fine, but like you can't carry over indefinitely. And even if you can, it's like you need to like put it for this purpose. So illegal spending probably is traceable in some respect to me as a user. So I think that that's a weakness in her argument there. Right? I'm not sure I can agree that the illegality of the expenditure has no impact on the amount collected, which is what her argument is in part. So I don't think I buy that. I don't think that's correct. It's a good argument. I like her try, but I don't think it quite follows all the way through. So I don't know if the court is thinking along those lines, but there is an element there. So there's something to work with.
Certification order that she issued contemplated was an extended period, a lengthy period of fact and expert discovery, additional summary judgment briefing, and potentially a bench trial to try to answer the hypothetical question of what any particular user would have paid for a download if certain expenditures hadn't been made. That is unknowable. We're not going to depose, the Chief Justice and the judges of the Judicial Conference to say, if you hadn't used this money, for the juror services back in 2014, well, would you have carried forward a surplus? Might you have accelerated the enhancements to PACER and CMECF? All right, or let's imagine you would change the fees somehow. Given the way these statutes are written, you don't know how. They could have done what they actually did quite recently as of January 1st, which was doubled the fee waiver per quarter. So it's now, if you don't accrue a fee and up to $30, you don't owe any money. They could have said, we're going to expand the individualized exemptions. This statute is so far from what we talk about as the paradigmatic illegal exaction claim.
Okay, so she has a point. She has a point, and I think it doesn't quite flow. Again, her point is we can't tell what would have happened in the alternate universe, right? So her point is I spent $1. There's no way for me to figure out, and I think she's right about this, there's no way for me to figure out like what amount I would have paid, or had they been restricted on spending, what they would have spent it on. So I can't like quantify the amount of my damage. But nevertheless, like my counter to this would be in every possible alternate universe, I would have been charged less, or I would have gotten more of the benefits that my money should have been spent on. So like, yeah, I can't tell you like how much I was hurt. I can't tell you what would have happened in the alternate universe, but I can guarantee one of two things would have happened. Either I would have been charged less, or the money would have existed for the projects that were the fund were intended to be spent on, and PACER wouldn't suck as much as it does. Which, by the way, compared to a lot of the state systems, it is much better than the state systems. So PACER is not like garbage. Because some of the state systems make me want to tear my hair out, which is just as good because I don't do a lot of state law, so thank God for that. But like, yeah, I can't quantify exactly how much I was hurt. I can't quantify exactly what the relief is, but I know there's something. And so that gives me, I've been injured to some basis. I had to have been. So, good attempt. She has a point, but I don't think her point follows through. Yeah. So let's play more. Play.
I still don't understand why this isn't a damages question. The judiciary should be able to figure out, here's how much it spends on these projects, here's how much of it comes from general appropriations, here's how much it comes from fees, and the court can say, here are the activities that you're allowed to spend fees on and how you parse it, and the excess that comes from fees over that they're allowed to incur fees for is the cumulative amount that was an illegal exaction. And how you divvy up that among the class, again, seems like a damages calculation to me.
No, because it goes to the basic point that Congress did not mean to give an individual PACER user a damages remedy that lets the PACER user come.
And the judge's question was very sharp, too, in response. So the judge's question basically is, well, that's what damage remedy hearings are for. That's what damage remedy hearings are for. Yeah, we don't know, but we could have evidence and testimony, and we could figure out like how much money was illegally spent, and we know the size of the class, so we can divide one by the other, and presto, we're there. Or we can say, oh, you should give the money back to the fund, or whatever. So yeah, it's like, yeah, that's what like a damages remedy is for. You know, we can deal with this. We deal with it at other times, and that she's back to, well, they didn't give you a remedy in damages, which is like, which to at least in my mind is conceding the argument that she's been trying to build up, right? She's like, well, you don't have a remedy in damages. Well, that wasn't really the question, you know, because I think, you know, but I think she might still be right about the money damages thing, because like she had a point. You can't get it under the APA. Does appear to exempt the judicial conference. It flows from the judicial conference, so maybe it's not a remedy here, and maybe you shouldn't read one in as implied, because it's not executive, it's judicial. That's more plausible, but all that other stuff she said is like, I'm not buying, but I'm still interested in the underlying argument about whether a damage remedy exists. That's a more interesting question. So hopefully that we'll get into that a bit more.
The court and say, like, imagine just an individual claim, because on their theory, this happens to be a class, but someone could come in tomorrow.
Counsel, why don't you address the merits finally?
I will adjust the merits, but I want to make very clear that we do not believe Congress put this court in the position of going back over the judiciary's internal accounting and expenditures and compelling the judiciary to produce documents that are exempt under FOIA in aid of the inquiry that the district court began to undertake in this case.
And instead authorize judicial conference to charge a fee even if it was knowingly, blatantly illegal, and to collect the fee and to have absolutely no remedy.
Well, to be clear,
that's your position.
We're talking about the judiciary.
Isn't that your position?
No, Your Honor, but we're talking about the judiciary.
Well, excuse me. Don't interrupt me, please. Let's assume that the judicial conference says, guess what? This is a great argument. We can charge everything we want for the fee. It has nothing to relate to anything. Has no relationship at all to the cost of supplying things electronically. We're going to charge for the curtains at the Supreme Court, the Chief Justice's new chair, and all the rest. Stick it in the fee. And we told the whole world we're doing that. We're redecorating all judges' offices with gold plate. And they do it. And they put it on the front page of the Post. And there's absolutely no remedy.
It's not that there's no oversight.
So I'm just telling you that's what your position is.
No, Your Honor, by statute, that the fee schedule, when it's changed, has to go to Congress in advance. Congress every year, by statute, requires a detailed description of the expenditures.
What Congress has shown in this case is that they love the fees because it means they don't have to appropriate. So we don't have to appropriate for the curtains for the Chief Justice. The gold-plated toilet, we don't have to appropriate for that. Great. Let the PACER users, what is it? It's 3 big users and a bunch of law firms. So let me ask you this question on the merits, just to test where you are. You know that the Supreme Court has a cafeteria. And it's not a bad place to eat, although Justice Gorsuch doesn't like the pizza now. So let's assume that on PACER now, you can hook into PACER and you can get the current menu for the Supreme Court's cafeteria. And the judicial conference decides that the cost of building up that electronic information should be passed on to PACER users because it's available electronically. Would it be appropriate to have that cost in the fee, yes or no?
The judicial conference has limited.
Yes or no on my hypothetical?
Again,
the cost of the menu, preparing the menu for the Supreme Court. Is that or is that not an appropriate PACER fee cost?
We're not saying the judicial conference would ever do this.
I'm asking
but the statute says.
Do you have a lot of trouble answering questions? Generally in life or just when you come in front of the court?
The statute says for access to information available through automatic data processing.
That was a little snip from the judge there. Did he say? Was the words he said? You have problems just answering questions. Is this just true in life or true in court? Was that what he said? That's kind of what I heard, man. Jeez, that's a little bit sharp for a judge, man. I'm like, geez, man. Calm down. You have a lot of problems answering questions. Is that life or is it just here in court? It's like, oh, man. They're giving this girl, they're giving this woman a much harder time than I think is warranted. Well, but as someone else was pointing out in chat, like they may have been making this other argument in other cases, and so maybe the court's getting a little frustrated. But like there is a context here that has to be decided. It's like Man, I don't know. I don't need that. I don't know that we need to go to the insults. Personal insults. It's like me.
Hypothetical covers that.
That information would be provide access available through automatic data processing equipment. But the next sentence also says, wait, you should be developing a fee structure that promotes public access and exempts persons and classes of persons for free.
People who go up there to litigate want to know what to eat the day they go and make the order electronically. You can do all that now on PayCert.
No, Your Honor, again, each year, these expenditures culminate in appropriations legislation. So Congress is presumably not going to say you can charge for the Chief Justice's curtains. But the point is, this is just a statutory claim, and Congress year after year enacts appropriations legislation in which it decides this is what I'm giving you direct appropriations for, and I've seen what you're planning to use PACER fee revenue for. And Congress doesn't have to accept that. It could modify it. But the claim here is that Congress should have appropriated direct funds for the particular programs, but not that Congress did do so.
Counsel, you're into your rebuttal time. Do you wish to continue to use it or save it?
I'll save it, Your Honor. Thank you.
So they give both sides holdover time, which obviously isn't the way the Supreme Court does it, but okay. So we're going to hear from the first guy again. I mean, she has a point. She has a point to be made. Like, the damage remedy issue in particular would seem to go to sovereign immunity issues. So if Congress doesn't allow for monetary damages, then presumably sovereign immunity would prevent you from getting monetary damages. Not necessarily injunctive relief, but if you want injunctive relief, then you're going to a different court rather than the Court of Federal Claims. So she has a point to be made that, this is the judicial branch. You can't get it under the APA because that's only for the executive. The law doesn't allow it against the judicial conference, and this is permeating from the judicial conference. And, so there's no jurisdiction here. Plausible. And I don't think she answered the Supreme Court cafeteria question, at least in part, because I just don't think it was that good a hypo. It's like, it's like she avoided answering the question, at least in part, because it wasn't very good hypothetical. And it was just like, So she fought the hypothetical, which I don't know if that's a good answer, but also the judge tried to put her in a box with give me a yes or no answer. And lawyers hate that because it's everything is nuanced. It's hard. It's genuinely difficult to give yes or no answers a lot of the time. So,
Mr. Cup.
Unless the court has specific questions about jurisdiction or damages, I want to jump to the merits. And
I have a question about damages, and I think this is probably for best left to Judge Uvell, but there's a number, right, for the CMECF category. Do we have any idea what that number means?
Well, I think this is what we were discussing earlier. I think what that number means needs to be fleshed out on remand. And I think, we've got some uses that we know are totally impermissible and unrelated to PACER. We've got the PACER expenses that we concede are permissible. And then CMECF is a category that may include some things that are permissible because they are truly necessary to the marginal cost of disseminating.
CMECF is what now supports PACER. The electronic docket that's created by litigants going on and filing documents is what allows public access through PACER. And so those two seem inextricably intertwined.
Well, I don't think...
Well, okay. Yeah. I mean, I understand you want to argue something different, but what I'm trying to ask you about is there are definitely portions of CMECF that are only used by the judiciary, the clerk's office, and the like.
Correct.
And actually aren't even necessarily used by the litigants.
Correct.
And so I guess for damages purposes, I wondered if you had any idea whether that broad category had in any way been narrowed down, or was it just from a budget line number for the judicial conference?
Right. Well, we've done no discovery. We've only gotten informally these spreadsheets, but we do think it's going to be possible to segregate out the CM component from CMECF, and we do think that's plainly impermissible. What I would suggest is that this court, because the court doesn't have a record really, that what it should do is interpret the statute and send it back to the district court to determine whether things within this CM category are truly necessary to the marginal cost of disseminating records to users. Because we know that,
Well, that's assuming we agree with your marginal cost definition. But I mean, assume we don't agree with
if you don't agree with
cost, and we agree with the cost plus infrastructure.
Right.
You still have to be able to allocate the infrastructure to those costs.
Well, right, but I think the devil will be in the details, because it is often the case in user fees cases that the government wants to take some of its overhead or infrastructure and attribute that to the service. We know that this is a service that is primarily for the convenience of litigants, right, in filing these things. It's not the whole reason ECF exists is not because it delivers documents via
pacer. You mean
pacer.
just litigants in a case who are doing the filing, as opposed to people in the public who want access to the information to write their own briefs or write articles or newspaper articles or whatever?
Yeah, I mean, that is certainly
a whole category of users, isn't it?
There's certainly a side effect of the existence of the CM system, which is that it allows for the dissemination of these records. But I'll just give you the analogy to the FOIA cases or to other user fee cases. The courts draw a line and don't allow, and I realize I'm eating into my time, but I would just recommend the New England Power case from the Supreme Court. It is not the case that the government can just attribute all of the overhead costs to the service. And I would suggest that the better course is to leave that issue to be fleshed out on remand. Thank you.
Thank you, counsel.
Yeah, well, that makes sense. Like, yeah, you would send it back below we want some clarity on the law and some other things you can send back below for some further decisions. So, like, trial court, you figure out, like, what these various amounts are, and you figure out in the first instance, like, the degree to which they are or are not necessary for the dissemination of public records in the electronic system. So, pacer definitely is. ECF is questionable. And I think CM is no. But as you pointed out, it might be more nuanced than that still. It might be that even portions of CM or portions of ECF would qualify and other portions wouldn't. But again, that's one of the things the district court can figure out. Because they do the factual finding, right? So they can do the factual record and figure out, how much money is being spent on these various things and how much is attributable, blah, 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 whatever. And I don't know enough about FOIA law to comment on the issue of the FOIA amount being attributable only to the distribution of records and not to the underlying system. I just assume he's correct. And it's a reasonable ask to say, like, what might be true in that case might also be true here. But of course, they're different statutes with different language. And so I don't know the degree to which that precedent, which I assume describes FOIA, that he described, the electric power case, which I think it is FOIA. I don't know the degree to which that automatically or even should read on to this issue. So it might be true in FOIA and not true here. So I don't know. And as I said, at least for me, it's like, I probably would want some of the money on infrastructure because we could use better infrastructure. I don't want the infrastructure to stay ossified forever. So, yeah. But it does sound suspiciously to me from the argument and the argument tone and the argument flow. It sounds to me like the question for the Federal Circuit is how much damages, not should there be damages. So, I'm obviously reading tea leaves, reading between the lines and listening to the questions and tenor and pacing and some of the things being said, but it seems to me like if I had to guess, the Court of Appeals for the Federal Circuit is sending this back down with instructions rather than killing it for jurisdiction. And they're looking like, how much should the damages be, not should there be damages. So that's kind of where I see this heading based on the argument so far. So, oh yeah, sorry. FOIA is Freedom of Information Act. Yeah, I apologize. Yeah, the Freedom of Information Act is an act that allows you to get records from administrative agencies. So if it's not otherwise public, FOIA is what allows you to get records from the administrative agencies. You can send a FOIA to Department of Energy and get a report that exists and blah, 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 whatever. All right, so let's see what's going on.
Ms. Klein.
Okay, just briefly, even in the user fee cases, the user fees generally build in infrastructure. They build in salaries, they build in overhead. It's not limited to marginal cost. The filing fee to docket an appeal in this court or other courts is $500. No suggestion that that's just about marginal cost. PACER itself is a portal to CMECF, as described by Judge Shovell. There's really little point in accessing PACER if you don't, in fact, get the records on CMECF. The electronic bankruptcy noticing is giving creditors information, case information.
So that's the one thing I wanted to ask you about, and I didn't get to ask you about on your opening, is she found that one okay, but not the notice to, I guess, local police officers and things like that about filings in criminal cases. I may not be getting the details right. I was curious as to if you thought there was a logical distinction between those two, and it could go either way over whether you should get them or not, because bankruptcy creditors are, in a sense, potential litigants or people affected. They're the public, but they're also affected by the specific case. It seems to me that sheriff's officers in the same way are a subset of the public that is affected, and I didn't really see any logic for the distinction between those two groups. If we thought one was good, the other one should be good, and if we thought it wasn't, they should both be out. But I didn't. Did you argue a different logic for chopping those
No,
out?
I mean, we agree, and also even for the standard PACER CMECF, there are some cases that are sealed, and so they're open to a subset of the public, not the public generally, like immigration and Social Security. Prospective jurors are also members.
I don't really like that answer. Open to members of the public should mean it's open to everybody. And to say that the people who are part of a sealed case are a subset of the public seems a strange thing, because when you're talking about a sealed case, the amount of people that have access to that file is 5. So it would be a weird thing to say that 5 compromises a subset of the public. Seems a strange interpretation to me. So yeah, I'm not really buying that.
Of the public, and since Congress has said you can have free use for categories of members of the public, so jurors get their juror summons electronically for free. That fits comfortably within the terms of the statute. I mean, again, remember, the statute just says access to information through automatic data processing equipment. It doesn't say it has to be housed on CMECF, which would have been an anomalous way to write the statute back then, since it was anticipating technological developments. The Mississippi
would carry the width of the subject matter beyond EMECF out to any information that the public might find of interest. Would you say related to the judicial system?
Well, again, we're talking about how the Judicial Conference had to read these instructions. It said access to information available through automatic data processing equipment, and then provide for exemptions. And it has to be read in conjunction
so the
with
Mississippi study, in your view, would be covered.
Yes, Your Honor. Though, also to be clear, that was $120,000 out of $920 million. So I don't think it's.
Money, but I mean that's an example that goes to the edge. For me, goes to the edge of what I think Congress sort of had in mind. I mean, if you are. The fascinating thing about this case is it's a statutory interpretation case, and we don't have a Chevron-type situation where there's an agency interpretation and all that pattern over time to follow. So it's sort of like the law before Chevron. And context matters. The context in which this...
It's statutory interpretation without Chevron. It's statutory interpretation without Chevron. Ah, be still my heart. Ah, be still my heart. There is no Chevron. There is no hour. There is no Brand X. Let it be every case. It's a miracle. It's so good. I'm just so happy. So happy.
The whole thing was created. And the context certainly doesn't include Mississippi by any shape, stretch of the imagination. And Judge Shovell drew the context to be related to case materials that are lodged in a judicial system, whether it's bankruptcy courts as well as regular courts, to which the public wants access. So why isn't that contextually a reasonable line that she drew?
The statute is written in anticipating tech developments. It's not meant to freeze things in time, and you wouldn't give the judicial...
Stop right there. How do we know that? The statute originally was created because somebody came up with the idea of PACER, right?
Right, but there's no, as Judge Uvell noted, there's no reference to PACER. There's no reference to a specific
Not in the
system.
statute. The context is what's not in the statute for interpretive purposes.
But you wouldn't give less deference to the judicial conference than you would give to an executive agency if, hypothetically, we had an APA cause of action.
Don't give any deference. There's no deference involved here, is there?
No,
You wouldn't give less deference to the judicial conference than you would to an agency. And he says, yes, I would. There's no deference. Oh, man. Because it's in a pre-Chevron, pre-hour, pre-Brand X world. So it's just interpretation of law. So that means it's de novo interpretation. Tell me again. Tell me again.
Of course there is. In fact, Judge Uvell applied a Chevron framework. It's just that the court concluded that the language was ambiguous. And
she didn't conclude the language was ambiguous. She said it's clear. She said both sides claim that the statute is clear, but that doesn't make it ambiguous. And she goes back and cites to sort of Justice Scalia has just rolled over twice, right? Just about what's going on.
Just to be clear, if you were going to deem the judicial conference's actions reviewable, the judiciaries, you wouldn't give less deference than you would give to an executive branch agency. Chevron is just a gloss, an assumption about when Congress delegates to a part of the government to administer a scheme. Here are the delegations to the judicial conference.
Oh, you want me to extend Chevron? You want me to extend Chevron? Because right now Chevron only reads on executive agencies, and you want me to read it on the judicial conference. How does no work for you? How does no work for you? Is no the good answer? Does no make you happy? Would I give less deference to the judicial conference than the agency if I were a judge? Yes, I would. Not for at least the reasons I want Chevron to die. And, it's one small start on the road. So would I extend Chevron? No way. I love it. You wouldn't give less deference to judicial conference. Yes, I would. Well, it's chaired by the Chief Justice. Look at my field. Look at my field. Look how empty it is.
That they get deference. And the text, but I want to make sure I touch on the courtroom technology, just because, as I said, the Mississippi study is a drop in the bucket. I don't think there's any claim it would have affected fees. The courtroom technology.
You're not going to confess error on Mississippi.
No, Your Honor, but
to be clear, you're going to let the lunch let the Supreme Court in.
I want to make sure that we address the bigger ticket item, which is that Judge Uvell, the way she analyzed courtroom technology, is that if it's, AV equipment and the information presented is then uploaded to CMECF, then you can count the technology expenses. But if it's presented to the public who care enough to come into court and want to see this case information available through automatic data processing equipment, it's verboten. And there's nothing in the text of the statute that would
Thank you,
have
counsel. As you can see, your red light is long and on. Please have your cases. Cases submitted.
All right. Oh, that was good stuff. Yeah, so she seems to have kind of lost the argument a little bit to me. She especially at the end is basically saying, well, it's an issue. The what I heard is like, oh, it's an issue of line drawing because the statute clearly contemplates this, this, and this. And the judges were saying, I don't remember the exact reference, but they said, well, something that they were considering seems like on the edge of what might fold into this. So it's an issue of interpretation where certain things do. Does PACER count? Sure, absolutely. Do other things count? Maybe, maybe not. To different degrees. So we analyze it and we do the analysis and fine. And so it's like, well, they definitely went too far, and and some of this is not within the scope of the law. And the judiciary has to follow the law just as much as everyone else, right? The judiciary has to follow Congress. So yeah, it was like, you shouldn't give the judicial conference less deference than you do an agency. And I'm thinking, you're right, but not for the reason you think you're right. You're right. I shouldn't give less deference because no one gets deference is my preferred answer. But I'm definitely not extending this. No, 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 no. Not happening. Oh man. Yeah, she did say verboten, yeah. I heard verboten. Yeah, I heard verboten. Or so I heard some German, yeah. Forbidden, yeah. I heard verboten. Yeah, so forbidden, yeah. You wouldn't download a Chevron with you. I'd kill a Chevron and murder a Chevron if I thought it would do any good. Oh man, that was a good oral argument. So here's my prediction, and it's hard to cast votes. It's hard to predict votes, not for least the reasons that I don't know the judicial ideologies of the judges well enough. So to split between 2-1 and 3-0, I can't split it. Too nuanced for me to be able to do that. But I think they're sending it back. I think they're going to say they do have jurisdiction, and they're going to provide some clarification on some of this stuff. And then they're going to ask the court below to make some findings on, the amounts that were spent for various things and whether or not those various expenditures qualify within the meaning of the statute or not. And that it becomes an issue of pure law on appeal. And so then the Court of Appeals for the Federal Circuit, again, when they get this back, can look at the decisions from the district court in terms of, well, here's all the money amounts, which are issues of fact. So that's fact. But here's whether or not it falls within the statute. That's a question of law. And so they can say, yeah, we agree with this or we disagree with this or whatever. But, it is a fact-informed legal analysis. So send it back, make them figure it out, and then, determine whether or not it was right or not. And then issue at minimum an injunction that prevents the government from spending money on anything other than what is authorized for. And maybe you issue some sort of damages remedy too. Not necessarily to the people. You could do that. But, all else being equal, I'd say the damage remedy should be to refund the pacer with the amount that should have been there in the first place. So the judiciary has to refund pacer, with the amount it should have been. And yeah, so that's what War Games, Lint. War Games. I know that one, man. War Games. Do you wish to play a game and all that stuff? Whopper, man. Whopper has taken over. And who said that line? It was General. What was his name, though? It was Baxter or something like that. Yeah. Yeah. Great movie, though. Great movie. Well, if you haven't already given the stream a like, I would appreciate it. There are 26 of you watching. I've got 14 likes. So if you're already watching, if you've gotten this far, I presume you liked it. So if you give it a like, I'd appreciate it. I published a video about 5:45, about 2 hours ago, on Missouri and alcohol related ads, which I thought was really good. Yeah. And yeah. And I think, if you haven't checking out that, I think it's good. So yeah, we will definitely keep following this case. So anyone who sees any developments in this case, when there's a district court decision, I will definitely cover that. When it goes back to the Court of Appeals, I'll consider that. And we'll go from there. Best hacking movie to date certainly had a lot of realistic elements, and a lot of hacking related terms came from that movie. Like war dialing came from that movie, so a lot of stuff came from that movie. It was very influential. So yeah. Oh, Sneakers is pretty good. Sneakers is a really good movie too. I don't know that you really qualify as a hacker movie, but Sneakers is really, really good. Ben Kingsley in that movie was really solid. Yeah, it was a really fun movie. So Sneakers was very, very positive. So yeah. Social engineering attack. Yep. Yeah, that's a good point. Very good point. Yeah, the social engineering attack. Yeah, very good. All right. I'm going to cut the stream for now. Please check out my stuff. Please like me if you haven't already. Subscribe if you haven't already. All that good stuff. And until for later, my friends, I hope you're well. Hope you enjoyed the stream. And cheers and goodbye.